Fine, thanks. How are you?
Good. I'm calling the meeting to order. It's 10 a.m. Can we see who's here? Dale?
I'm here.
Roll call.
Bob Wagner.
Bill Feierabend.
Stephen Cooper.
Frank Thorwald. We have
Dennis Turner as the administrator.
Oh, you wanted me to introduce myself?
I do.
Never done that before. It's a new year. I'm Dennis Turner, the Oil and Gas Administrator.
and Rick.
I'm Rick Zeiss from the Attorney General's office.
And we have a quorum. We have on our first agenda item the approval of the minutes from our previous meetings, one of which was amended. We had previously approved it and it had been amended. Do we have any discussion on those
Just
on
to
the October 21st meeting?
Yeah, just to explain, they've been previously approved by Frank. I never posted them on the website, however, because shortly after he approved them, I realized that what I'd originally intended is that today's meeting be held in Tucson, but the agenda started to fill up with some really important things, and so we nixed that. And what I published in the October 21st minutes was a little bit different from what's on the screen. So that's the amendment that's in the minutes to be approved again today. That's the only change.
Any other discussion? Any comments? Do I have a motion to approve those minutes?
Mr. Chairman, I move to approve the October 21st, 2016 meeting as amended and the November 15th, 2016 public hearing minutes.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Any opposed?
Aye.
Okay, well, the ayes have it. Third item on the agenda, discuss Ranger completion. Dennis, do you want to take us through this?
So we're not going to be making any decisions today. The key player, Tony Hines, was unable to make it, but I just wanted to kind of frame the discussion as to why it's even on here. Being kind of the newbie and new kid on the block, as I read the rules and based on my experience as an oil and gas geologist from the past, there is a passage in there which I hope you can read. If not, I can magnify it. In fact, I just will. Agenda number 3 there. The rule citations are 116 and 137. They have to do with multiple zone completions and commingling. It just says basically there that the commission needs to approve that if an applicant wants to do that. And we did not discuss that in any of the presentations that Ranger made to us in the past. I think it was just an oversight, and I thought for the record it needed to be discussed and a decision made by the commission. We can't make a decision today. Like I said, the key player that has all the technical expertise to go through it with us can't be here today, so we'll have that discussion and a decision on the 17th of February. But as I understand multiple zone completions, it means if you're trying to complete in 2 or more formations simultaneously and want to produce, then the commission needs to provide its input, approval, or whatever. And the same with commingling the production. I mean, in my mind, they're kind of the same, but there are some differences. And so that's the reason for it being on the agenda. Rather than me take it off, and also because it was kind of late stage at this point to try to take it off the agenda, I just decided I'd use this time to explain what our intent is. It's not that we're going to derail what Ranger is trying to do, but just to keep things on the up and up, if you will. And then it can be documented in the minutes that we discussed it in February 17th that we voted on and so forth. So, any questions or discussion?
I have one question, Dennis. R12 7-137 talks about commingling production. It almost sounds a little bit like a specific oil production.
Mm-hmm. Yeah, I wondered that too, but that's why I mentioned it, is if there's some feedback or if there's people in the room here that have more experience and background with what the intent of that rule is, and that it only applies to hydrocarbons or specifically oil, you know, I might take that as a little feedback for my write-up on 5-year review stuff, so.
Dale, do you have any thoughts on that?
I kind of missed out on what he was saying, but I think the issue is, does it apply only to hydrocarbons?
Yeah, does it apply only to oil? That's kind of Joe Dixon's question, is does it apply only to oil? Were you having trouble hearing me, Dale, or I can speak up if you are.
He was.
Okay.
Excuse me.
Did you have any feedback for us, Dale, in regards to what your interpretation is of
Well,
Section 37?
certainly, I think we've discussed in the past that, you know, gas is gas, you know, whether it's hydrocarbon gas or carbon dioxide or helium, and then of course nitrogen's involved here. So the rule, I thought that rule covered gas. I have to look at it again, but I thought it specified in case of multiple completions that you had to have pressure information relative to each zone. And of course, in this case, we're talking about the Shenarump conglomerate as one zone and the Coconino sandstone as a second zone. So they would have to be completed separately to get the engineering data that's necessary to meet our requirements. Then, if it's decided, then, and of course that requires a public hearing to approve that. But the rules specify what kind of data have to be gathered for each zone as they're written. Then of course the commingling would be another issue if the completions were done separately and testing done separately for the different zones. Then another issue would be whether you wanted to commingle the production from both those zones. And that would require a hearing, and of course they would have to justify that this would be an efficient process. There'd be no loss of energy as a result, and other things that are actually covered by that commingling rule.
Can I ask a question here?
Go ahead.
As an oil and gas guy, now what you're talking about completion is you drill one hole, but you isolate one interval from the other while you do testing. Is that correct?
Yeah, that's right.
Okay, perfect, okay. I thought so.
You have to use, you have to use packers in the hole,
Yeah,
separate the zones.
okay.
Any other discussion on this? Questions?
Oh, the other thing I'd have to say about it now is, today we only need to discuss the rule. We're not going to take any action on the, the actual process by the operator. So I think that if what we're doing today is just reviewing the rules.
Correct.
Any other thoughts on or questions about the rules? In that case, we'll move on, and any decisions we might have to make, we can discuss at our next meeting in February.
Mr. Chair, perhaps maybe a better motion would be to table this matter to the February 17th meeting.
Good thought. Is that a motion?
Yes, it was.
Second. All in favor?
Aye.
Any opposed? Okay, the ayes carry it. It's tabled to the next meeting. Number 4. 35-1 permit 919 status. Dennis?
This is where I'll rely on Niall Nemeth to some extent, but I just framed the discussion that there was some discussion at a meeting of the commission in April to bring to a closure the status of the Hortenstein 35-1, which is right near one of Ranger's producing wells. when I was in the field performing inspections with Tony, he took me over to the location where the port of steam was and said that he had had some discussions and they were interested in, I guess, re-entering the well or something to do their own thing, and they might take over responsibility for the well. The piece that was left dangling in April was that what was the Commission's action going to be in regards to Holbrook Energy Partners with regard to, as I understand, a failure to follow the procedures in plugging and abandoning that well. It was drilled approximately 10 to 12 years ago. But what happened is that the Arizona Geological Survey kind of ran into a brick wall. They closed. There was a meeting set up for the 20th of May, which had to be canceled because Nile was up to his ears in alligators. And, you know, the practical matter was just couldn't address it. So I've just kind of resurrected it. And at this point, anything else that Nile wants to add to that, since he was there.
I think the only thing I could add is that Rick and I drafted a letter which got sent to the responsible parties.
I have that letter in my hand of April 21st, 2016, signed by Frank Thorwald, that was forwarded to Holbrook Energy. If you look at the copy I have, and I can represent to the original, that it was, I have return receipt requested with return receipt numbers. So I can represent to the board that it was appropriately mailed and appropriately received. The issue was what to do with their bond. And within the letter, it was our position that they forfeit the bond because they failed to properly abandon and plug, and they missed their time frames. And that was the position we were going to take at time of the meeting. It never was resolved.
Did they respond at all?
We've had no response whatsoever.
Should have put it on the screen, the letter, or not?
If you want to put it up on the
I
screen.
mean, I don't know if it
I don't think-
facilitates the discussion or not.
I don't think it's going to facilitate it that much of a
Okay.
discussion.
Okay.
Is there anybody here from Holbrook Energy?
I was a member of Holbrook Energy, and we did respond to a lot of communication with Nile. We agreed to plug it, and then we were, that's when we started having some conversations with Ranger.
Before we go any farther, can you identify yourself, please?
Oh, I'm sorry, Gordon LaLaw.
All right, Mr. LeBlanc, if you could start one more time, please. Start your discussion one more time.
Upon receipt of this letter, we did respond and had numerous conversations with Nile. I told them we would plug the well, but there was an interest in Ranger at that time to potentially take over that well. And I've had discussions with Rick Porter. Rick, you right here? Okay. How you doing? Good. And we've had ongoing discussions about that. And I had spoken with Dennis about this when he came in. So we're at the point that you still want to take over the whole.
Rick, our position has been we would take over the whole. But at the same point, we needed something to resolve from the state authorizing us, because at the point we were talking with Gordon, we didn't even know where the current status of the company was, even Holbrook Energy.
Yeah, I'm no longer a member.
And we needed to do something with Holbrook Energy. We didn't know who it was out there at that point. We just thought we needed to do something with the state of Arizona, make sure we had the rights to do it, which we own a gas lease, we own an option underneath it. This is Tom Wallace, one of my partners from Denver, he can summarize too. But we have the rights to be able to own the oil and gas lease covering that area, that lands right now. So, and as we see it, Holbrook Energy at this point has no record title underneath that section at all. We have a surface use agreement covering it, everything.
Correct me if I'm wrong, Rick, but I believe our discussion at that time was that you would take over the well, you wanted it for the data that you could generate from the well, and then when you were done, you would appropriately plug the well pursuant to statute. And the our problem was, or the problem with the board was, we have a bond sitting on it. What do we do with the bond? Now, one of the problems right now is Mr. LeBlanc has already indicated that he is no longer associated with Holbrook Energy, meaning unless he can provide a little more information as to where that money should go, I would be hesitant to release it, and we can go through that issue later. As to your moving forward on it, that's something the Oil and Gas Commission Board will have to make recommendations and take a step on.
Yeah, again, my name's Tom Wallace, and I work for Twin Bridges Resources in Denver. We're a working interest owner in Ranger development. It's a fee mineral tract where the well sits, and we have a oil and gas lease with all of the mineral owners on that tract. And we also have a surface use agreement to operate on that surface estate on that mineral tract. The well, as we understand it, from all the well file data that's available, is that it's not plugged. That there's a valve or something on top of the casing. Casing is cemented. We think that there's potential opportunity to perforate above the target formation and potentially produce and tie it into our existing infrastructure and produce the well for the benefit of the fee mineral owners. If that does not work out, then we would plug and abandon the well. We would cover the operations with our existing bond, and because it's sitting there unplugged, it's of no use to anyone in its current form, and we don't know exactly what result we're going to get from it, but if it doesn't work out, then we would satisfactorily plug and abandon the well and put a dry hole marker on it, and that'd be the end of it.
This is the status of it as of December 8th. It's excerpt from my inspection report. Properly plugged well would have at least a 4-foot steel monument with a labeling on it as to what well it was, so on and so forth. I can't see any cement that's oozed out around the annular spacing or anything, so
Dennis,
that's its condition as of today.
Niles, was there any formal responses from Holbrook Energy with respect to the bond?
Formal response to me, I interpret formal to mean in writing, and I don't recall anything in writing. Yes, Gordon and I have talked about it. I took in the information because he was filling background for me. I was so new that
But what I'm
Dave in the woods. But as far as Niles, he has to answer. I don't know.
What I'm really asking is, besides the takeover by potential takeover by Ranger and inclusion in their bond, was there any discussion on or response to our letter on what they wanted to do with that bond?
Unless something got sent to Kendra down in Tucson, I certainly received nothing and never got anything reported to me as a formal response.
And Kendra never sent anything to me during the period of time that the...
No, and I just to make it clear, I specifically, asked her.
Yeah.
So if something came at the last days when Kendra was still on board at the survey, I left late in June. She left at the end of June, so there's a small gap there just to avoid the confusion.
But as it sits today, there has been no formal written response from Holbrook Energy to to your knowledge, to either the Arizona Geologic Survey nor to the Oil and Gas Commission at the time you were the administrative wing, or?
That's correct, Rick.
Okay.
And Dennis, you've looked at the folder. You didn't see anything.
I don't remember seeing anything. I could go
Kendra,
fetch it
anything
if you're interested. I'll tell you
But
about
numerous
it.
email correspondences with Kyle on this subject.
Gordon, is the one issue though is you weren't officially a member of the corporation. That's the responsible party. So I think that's where we're addressing the formal response.
That's the reason I'm addressing formal response right now, is You've already indicated in this hearing that you're no longer associated with him. What that means to me is that you cannot speak for them. And if you look at this from the point of view that Holbrook Energy is a separate entity from you, unless your name, and I hate to be specific in particular, but unless your name was addressed with the deposit of the $10,000, then from my view, you would have no current standing to challenge the board in taking any steps as to this bond on behalf of Holbrook Energy. That's my point. And so what we're trying to do is to do two steps here. The first step is to determine what to do with this bond, and the second step is to see what is necessary if Ranger is interested in using it to transfer to Ranger. Is that where we?
Absolutely.
That's kind of what I figured. And so, as to the bond issue, the board has the ability, because they've given notice today and notice in the past, to make a decision regarding what you want to do with the $10,000 bond. Now, by statute, based upon the improper, as indicated in the picture, the improper plugging, and it is not plugged, and based upon statute, you could forfeit the bond. You could take a vote to forfeit the bond. The bond money would then come back into the Oil and Gas Commission. And then the next step is what is to happen with the well, and that point is the board can make a determination or some finding that Ranger would be entitled to use upon appropriate formal request. That was my thinking.
Members, is there any discussion on this? Thoughts, questions?
If we vote to forfeit the bond, the money comes to the Oil and Gas Commission.
Yes.
Do we then use that money to plug the well?
You can't. That's the purpose
or
of the bond.
Can we pass it on to a successor
We
to
can.
use to plug the well at our
That-
direction?
My current recommendation is I'd like a little more time to research, but my belief is that it could be passed on because the purpose of the bond was appropriate closure.
Right.
I'm not sure I would suggest a vote on transfer of a $10,000 bond to a subsequent plugger, the person who plugs the hole. But as of right now, my suggestion is the board may want to make a finding in regards to the $10,000 bond and its forfeiture. And I see it as a two-step process.
Do we have any information as to who we need to contact at Holbrook again?
In contact.
Do we make another attempt, or have we taken care of that?
Here is all the folks that were contacted.
He's looking at the April 21st letter of 2016, is that correct?
Yeah.
That's correct,
Yes.
Steve.
Okay. That letter talks about a hearing basically being in May 20th on that. And obviously, as we sit here today, it's not May 20th. My concern is that the agenda item talks about the status, inspection, and responsibilities of interested parties. It doesn't say that that we're considering forfeiture of the bond, so I'm a little leery about moving forward on that. I think certainly if we noticed at our hearing in February 17th, which we are rapidly filling up, that basically I certainly would have a problem with basically considering an action at that time.
Would you make a motion of that? Mr. Cooper?
You want to make that motion?
I just wanted to make sure there was no more discussion amongst the board about the issue.
I'd like to say something. Mr. Dale?
Go ahead, Dale.
It seems to me the commission has every right now to forfeit that bond because the operator did not meet their requirements to plug and abandon. They just left it open. So to me, the commission could forfeit the bond and then still work out an arrangement with Ranger for them to take over the ownership of that well, and then they would be responsible ultimately for plugging and abandoning or producing it if that's the case. But I would encourage Ranger to take it over and see what they can do to make it a productive well, if possible.
This is Bob Wagner. I agree with you, but I have this same concern that it is not on our agenda today to take a vote. And
No,
that
of course
concerns
not.
me.
Yeah.
In the meantime, I reviewed the public notice and meeting agenda for today, and I'm in agreement with Mr. Cooper that there was no indication of a possibility of the board taking a vote today to forfeit the bond. And that's my suggestion. It'd be calendar for appropriate agenda based upon appropriate motion.
Could we put both parts to the question on the agenda for February 16th? Or does it have to be one and then another meeting, the second part?
I think you can put both on the agenda next time.
And move to finish this,
Yes.
wrap this up, okay?
I think that's a good idea.
Okay.
Mr. Chairman, I would move that we table item number 4 to our February 17th meeting, and that we, at that meeting, have two matters. One, basically, the Hornstein 35-1 permit 919 status inspection by Oil and Gas Administration responsibilities and duties of parties, and subpart to that is possible forfeiture of the bond that was posted in this matter for non-compliance with Arizona Revised Statute number 27-524E.
Do we need to add anything about any recommendations we might have regarding Ranger?
I would suggest to you that perhaps we deal with that, possibly a second motion after we do this one.
Okay, I'll second yours.
All in favor?
Aye.
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 Any opposed? Motion carries. It's tabled till the February 17th meeting. Regarding Rangers,
Okay, yeah, so that was the second part. Are you going to move now to the second part? Or?
Commissioner Wagner had a suggestion that perhaps we do a second part, second issue.
I believe we need to either discuss it further or put it on the agenda for a vote. I think we need to have some discussion on that.
Yeah.
Ranger can bring it up and discuss it at our next meeting, and then we could have a vote on it.
At the meeting?
Yeah. This is
Okay.
Stephen Cooper. My specific concern is that we're asking them, we're asking to take an action that they may not have applied for. Certainly, we can encourage them to make that application
Sure.
to basically.
I understand.
To basically receive, to basically apply to take over that well, which we could consider at our next meeting, but I don't think that we can.
Yeah, understand.
Well, we'll do that in advance of the meeting, so we'll do that immediately.
Okay.
So would we be in a position at the next meeting then to take care of the second part and wrap this thing up?
You would.
Okay.
Yeah.
We just need to be able to coordinate with Dennis, where, put our application or whatever process we need to do with regard to that and have it ready for the 17th.
Just for the record, the existing bond between the state and Holbrook Energy is none of our business or concern. And so Ranger is willing to accept the liability for taking over operations of that well. And we want to do so directly with the state and not have any dealings. Whatever happens to the bond is between the state and Holbrook Energy, whoever that is. So we're not asking for a transfer of the bond to us or be beneficiaries of it. We're willing to provide our own means to.
Well, this could be put on the next agenda without our voting.
We don't
on it
have to
now.
vote
We
on
don't
it.
have to.
Mr. Chairman, I just comment briefly. This is Stephen Cooper. The matter that we took, the action is that Holbrook has the right at the February 17th meeting to contest the issue of the forfeiture of the bond, and perhaps anybody that is an interested party can certainly come and appear before us and claim why we shouldn't forfeiture the bond. The bond. With regards to Ranger's actions, certainly it's entirely in their control. We want and have sent a message to anyone that is doing business for their own gas commission that we'll work with them, and we'll get this on the agenda as soon as they believe that Ranger has got this in a position where it can be placed on the agenda for consideration. But obviously our intent is that we've got a well out there that hasn't been properly plugged and abandoned, and we want to resolve the issue one way or the other.
Does the land department have any issues on any of these items we're discussing?
Not that we're all particulars, not on us.
Okay. Any other discussion on number 4?
So are somehow in this whole discussion, do we need to do anything as the board about Ranger taking over that well, or is that an administrative matter only?
I have to look into the rules. I'm not sure I think the rules do address something about transfer of ownership, and I don't know if it's just a simple sundry notice, a letter, or a formal application to drill, but I'd ask Ranger to hold off on filling out any forms. I'll give you a call in the next few days and tell you what to do.
Okay. But can we, kind of deeper down, my question is, can we sort of resolve, if we resolve the bond at the next meeting, can we also, if we need to as a board, can we also resolve with Ranger moving forward on that, or is that a matter that does not include the board?
Well, so I think that's a
Do you
procedural
agree?
question.
I am not sure if that's going to be a discretionary administrative function. I would have to go back, as Dennis suggested, and read the transfer document. My guess is it's going to be administrative, it's something Dennis could do, but I don't want to foreclose the board from discussing it, certainly.
Yeah, okay. So the next question is, then, do we need a motion for the board to do something pertinent to Ranger at the next meeting, or should we wait till the meeting after that? That gets down to the heart of my...
I think we should wait and see what develops between now and then. I mean, it could, if something develops, it can always be added to our agenda for next meeting without any action by us.
Absolutely.
Yeah, I think if staff and Ranger are satisfied what they believe is that they've got this properly, they can get it for us, we can act on it.
Okay. Are you guys good with that? Okay, great.
Is that, in other words, we can conclude this matter at the next meeting if we have all the ducks in a row?
Yes.
Yes.
Yeah.
If there are ducks up there.
Yeah. Yeah.
And if we have a big enough shotgun. We're then moving on from number 4 to number 5. Dennis, do you?
Before we move on, do we have to have a motion and a vote
Oh,
to table number 4 and the rest of the issue before we move on to number 5?
We did that.
The motion that I made, and Mr. Zeisen, certainly, if you heard differently, I'd be happy if you don't go back there, but I believe it was a two-part motion. One was to table the item as it was laid out in the agenda, and the second part of that was to have a separate item for possible forfeiture of the bond in accordance with Arizona Revised Statute 27-524E.
All right,
I think we voted on that.
then we move on. Thank you. Just want to make sure.
Item number 5, AAC R12-7-121C interpretation. Dennis, do you want to?
Confidential records.
I know this is a discussion on this particular.
Yeah. Well, I'd like feedback from members of the commission as to what is meant in 121C about unproven territory. That's kind of vague. This arises because, if I've got the company correct, Mr. LeBlanc's company, Arizona Energy Partners, is that what it's called? No. Had asked for confidentiality for completion records on a well they've been working on. And I haven't said yay or nay because I got to looking into it and wondering, I think this well was originally drilled approximately 10 years ago. And this is a question, this is not a veiled agenda of any kind because I'm so new and still learning about a lot of procedural things with the rule. I really don't know, but is this the first time that any data has been generated out of the well after 10 years you went back in to do completion?
Data generated in 2014 when previous zones were tested.
And then these were
And then we set a plug.
a new zone.
Could you speak up a little bit so that Dale could?
There was data generated in 2014 when we went in and perforated and tested 3 different zones. Then a plug was set and United Helium stopped at that point. We come back in under, we reacquired the leases and here in December, went back in and tested 3 zones above those perforations that were tested in 2014. So we've got gas stream analysis, did an 18-hour flow test, and that was the purpose of the request as far as keeping information confidential. This is completely new. These are zones that we've opened up above that.
Okay, well, that probably answers my question, then, because the basic question was 10 years after, are we still, who will still authorize us to hold things confidential? Well, it sounds like it does, but any feedback from the commission on that matter would be appreciated.
Yeah, I have an opinion on that. This is Dale.
Yeah, go ahead, Dale.
They clearly have new information, regardless of how long ago that well was drilled. They developed new information about potential production, and I think they should be granted a one-year
Confidentiality?
confidentiality. Yeah, I think they should, because of that, I think they should get the one-year confidentiality agreement approval.
Yeah, that sounds good, seems reasonable to me. So the question before the commission then is the date of Mr. LeBlanc's email, would that be the effective date? Its original email to me, is that the effective date of the confidentiality for the 1 year, or is today's discussion make it? I didn't make a decision either way.
They're requesting it now.
Well, he made it in writing in an email to me back in, I don't know, plus or minus early mid-December.
December 15th.
Yeah, okay, it was December, but I was going to say that.
Yeah, that'd be a good time to start it.
Just started December 15th, okay. I'll formally respond to your email, but I'll put it in the minutes. And the clock starts ticking then from December 15th.
Is there a need for us to vote on that?
I don't think so. I just wanted some feedback based on experience of other members of the commission. However, in regards to this agenda item, I note this word called unproven territory. And historically, has there been any experience or standard interpreting what unproven territory means?
Dale?
All of Arizona is unproven territory.
Rick, from a legal perspective?
I went looking for a definition and couldn't find one. So, based upon that, I would rely on the board's belief and representation without further research. But I went looking for a definition.
Is that just a general term that's been used, or is that something that has some meaning to the industry itself?
Oh, that's my question, basically. Yeah, there's no definition.
I'm not part of that industry, so I wouldn't know.
One of the reasons I want to bring it before the board is because we have Mr. Firebrand, who has background in geology, and we also have Niall here today with a background in geology. Is that a term of art somewhere that I missed in looking back through either both federal and state law, to your knowledge?
I have, that's a new specific term to me. I mean, when somebody says it, an image comes to mind, but that may not be the legal definition of what the two words mean. Okay, Niall?
Well, I have an opinion there. I think that would differentiate most of the activities that are going on in Arizona, in contrast to where you have a producing a field, and you're just drilling wells to extend extend the exploration of that particular field. Now, but the field meaning a certain structure like Denibakea or one of the other, like Pentadome, within the confines of that producing field. Anything outside of that should be unproven territory. That's my opinion.
This is Frank Thorwald. Given that there is questions with regard to what the interpretation of this is, it seems to me like that we should research this further and see if there's any accepted interpretation nationally or internationally, and if not, we should use put out what our own interpretation is, so there's some clarity in the future on this. And I personally like what Dale has stated. Can we, Dennis, can you do that?
Yeah, and then
And add it to the agenda for a future meeting?
could do that also. Digressing just a tad though, Niall and I are going to be developing a number of, I won't call them the guidance documents, but something published that's a little more official that establishes things like these kinds of policies. It may be nothing more than a bullet list. It's not, it's just a gleam in the eye right now. It's stored up here in my head, but Niall and I will be putting things together in the next few months that will probably be added to over time. I mean, in the past, some of this stuff's been documented in the minutes, but I don't know which minutes. They may have been from 2011, 2008, 1997, you know. So it'd be nice to have a compendium of these kinds of things as they come up when they're valid questions. And so this might be something that would go on like a guidance document, not really, but something that's published so that future administrators can refer to it and the public can see it. So there's a standardized approach to things.
So what I'd ask Dennis in going through and drafting that, I think that's a great idea, is it's presented before the board as it grows and is developed for approval.
Yeah.
Is that okay with the board to do in that manner?
Yes.
Or would you prefer in another manner?
Fine with me.
There's nothing to produce yet, but in the next few months, hope to have a straw man document anyway.
With respect to that, Dennis and I had talked, and after some of our tours around the state with Niall, I discovered that some of the parties that we're working with out there, the different companies, didn't have good clarity on the regulations and rules and so forth. So I asked Dennis if he would put something together that would give them more clarity, draft some things so we could look at it as we move forward.
That's an agenda item actually for today. It's towards the tail end of the meeting. I've got something to show you.
Okay.
And Dennis, just for the state land perspective, Council will help clarify anything. We have different leasing rules for state lands, whether something is considered to be a known geological structure or an unknown geological structure. And to get something from unknown to known, you have to put this panel together. It's, involves a couple of agencies. I don't think even exist anymore in the old statute there. You know, we, like Dale says, you know, we've always considered, you know, everything on state land to be an unknown geologic structure. You know, about that provision there too. We never had to really try to designate anything as a known structure. Although we kind of thought about a little bit with the St. John's CO2 field, which might have helped capture some of the best we had early on, but some people leasing there, you know, kind of the same provisions a little bit.
Is the core issue between unproven and proven is the confidential records? That's the core issue.
Yeah, that phrase is used in confidential
And the difference between the two and how you handle confidential information is...
If there's a request from the public for a look to the well records from a well that's in unproven territory, then I withhold certain stuff.
But if
because
it's
of
in a
confidential.
proven territory, you'll fulfill that request.
They get the whole kit and caboodle. They'd still get certain contents of a well file regardless.
Okay.
Like their application to drill, I guess, that kind of stuff. But
Location,
whatever,
yeah.
the rule spells out specifically what is
Okay.
confidential.
That's
Right
the
now,
core
it's-
issue is
It's the core issue.
release of information.
Yeah, I want to make sure I'm not, you know, doing something that's wrong or illegal and not the rule.
Really the difference in release of information is just the time span. They have X amount of time. If it's unproven territory, certain information remains confidential for a certain period of time and then becomes open public information.
Unless they present before the board, and I don't know, remember if it's a formal meeting or just submit a written document that asks for an extension. And then the commission does make that decision whether to extend it or not, but.
Okay. Yeah, okay.
The rule, it's R12-7-121. They're supposed to file the report within 30 days after the well's completed. They list 7 items there, and they also, of what needs to be filed. They list core samples, and then when we get to the confidentiality provision, it says the commission shall provide notice to the operator at least 60 days before the confidential records become subject to public inspection, which is the 1-year period. And the operator can request a period from 6 months to 2 years from the date of the request if we find they provided us credible evidence that disclosure of information is likely to cause harm to the operator's competitive position. So procedurally, I think we have to give them notice that it's, you know, they're 60 days out from their 1 year and that everything they've filed is going to be public, and it's up to them to request an extension and show us, you know, some reason why this is.
Yeah, it's fair enough.
Yeah.
Okay. It's reasonable. Okay. Just wanted to be sure that we're, okay.
I wanted to ask you, it doesn't really say on the agenda, but are we talking about a specific well here for this confidentiality thing, as opposed to just?
Well, what started it was a discussion between Mr. LeBlanc and myself on the HNZ 17-1 when he was requesting confidentiality. But it started in my mind thinking about, so I'm reading the rule and I'm seeing this word unproven territory, and I'm thinking there's people in the commission that have dealt with this before and have some experience. So what in the world does that mean? And there is no real term of art from my geologic background as to what that really means, but maybe that doesn't need to be a formal definition in the rule either. But I think the way we're proceeding and analyzing it is what I expected, and I appreciate the feedback too.
Is a question with regard to the laws, regulations on this. Is there any anything that we've seen in here, or any issues that have come up that need to be reworked or clarified within the legislation itself, given the new legislative session has started? And are we even allowed to do that at this point?
With regards to this specific regulation, as I see it, you know, the first question is whether a 1-year period really, in, you know, today's age is sufficient, something that we could look at. But the operator has a right to request confidential extensions for 6 months and up to 2 years, so they do have some protections there. However, I think administratively, we're going to have to basically get a tickler system in our records that when they, you know, 1 year after they file, that we're going to cut a letter telling them it's going to be confidential. And then the ball's in their court to request why it shouldn't be a public record, and they're going to have to show us some evidence of why this would hurt their competitive position.
Yep. So if I look at this from a board point of view, the actual letter itself is it's an administrative function, but the decision to grant an extension is a discretionary, meaning the board should take it under submission at a meeting to determine if there's going to be an extension.
Yeah. The rule refers to the commission, and I've not looked to see if somehow the commission would also include basically our administratively acting on behalf of the commission. But I do recall one instance where someone in a prior meeting, and I can't tell you when, did come in, we had a formal hearing, and they request confidentiality status, and after hearing it, we did act on that.
Yeah.
I remember that.
I do too.
The reason I bring that up is because there's a previous Attorney General opinion in regards to what the administrative portion of the commission is, which is Dennis Turner, versus what his powers are, and that can be only administrative. But if there's a discretionary decision to be made, such as granting a right, that is something the board has to undertake. And that's the reason I kind of brought it forward. That's an opinion of, it's back in I believe it's 1961, but there has been no other
1960.
1960.
Is it possible you have a copy of that?
Yes, I've already sent you one, but I can get you another one.
Well, Dennis may have known about it. He was around in 1960. So.
Well, in fact, the first meeting of the Oil and Gas Commission occurred on my birthday in 1959.
You know, not at the next meeting, but at some time in the future, maybe we should have a policy where we have basically what the line is for Dennis's protection of the things that he's required to, he can do administratively, and what we believe the things the board should be doing. That way, I think that might make it a lot easier for everybody.
I agree.
I agree too. I think that's a good suggestion.
That's a great suggestion,
The
Steve.
entire state is unproven. You have a set procedure, right there.
Mhm.
To me, the procedure is reasonable.
So what's the resolution in this last item?
With regard to these same issues and confidential, well, we'll bring it up something else later. Any other discussion on item 5? Then let's move on to item 6, extending blanket temporary abandonment. Dennis?
Yes, so I was busy writing some notes for the minutes, but let me just pull up the, for background, there are 2 minutes in the archives. One is from 2011, another from 2013, where a discussion with Kinder Morgan was had about blanket temporary abandonment status. It's either Mike or Tom have explained to me there was a time when they were blowing and going and drilling wells like crazy because they were going to produce CO2 and have a pipeline and so on and so forth. But the price of oil went to whatever it was. I don't know if it went to $10, but anyway, it kind of made it uneconomic for the time being. He decided that the best thing to do was to temporarily shut in these wells until such time as it makes sense in the future. But because you had so many wells, rather than submit an application for each individual well, which just produces a lot of paperwork, you ask for a blanket status or permission, I guess, and then you would just update us in regards to how that happened. Is that understanding correct? And I'm asking that of the board too is that pretty much right?
Yeah, in a nutshell.
Yeah,
That's what
I mean,
it was.
I'm
We were
kind of abridging it, but.
We were coming before the board every time to submit a TA as we were drilling the wells, and the meetings were spaced at that time quarterly. And so we only had so many days to TA a well. And so we just went with a blanket TA until we were able to produce at our plant facilities and pipeline place.
And there's 2 places in the minutes. One, well, I guess I could show the screen here. There's 2 places in the minutes here where you can see in my file. It was something in 2013 that gave them the blanket status, but the original discussion, I guess, was 2011. The thing that kind of perplexed me, though, is that something that Steve Rousey had sent in answer to how this works, that is driving this agenda item. The TA period is for the duration of the unit. The unit, I guess, kind of has a lifetime being on state land. It had an expiration date, which was this month, and had to be renewed, which I understood from Joe yesterday got renewed. So my question is, do we need to renew the TA status? I mean, as written here, and just maybe being too anally retentive about it, but literal, seems like we need to decide, are we going to extend the TA status, or is this an infinite thing that can go on without the board addressing it in the future?
It looks to me like we've approved that already, the extension of TA status on a blanket basis for the duration of the unit.
For the duration of the unit, right, but the unit expired and had to be renewed this month. So does that mean our deal expired and needs to be renewed?
I don't think so.
Okay.
The unit still exists. I mean, the unit has been reapproved, is that right?
Yes.
Yes, Joe said yes.
For how long, Joe? How long does that extension last?
Another 5 years. It now goes until January 31st, 2022.
Okay. Well, our approval certainly should extend through that period of time without any additional action.
What the motion was in January 18th of 2013 to grant temporary abandonment to permits 989 through and 1083 and future permits and drilled productive wells for the duration of the St. John's unit. And that was voted on at the time, and the motion carried unanimously.
Yeah. To me, that covers it.
Frank, if you could go back one paragraph. Just above that, there's a paragraph, Mr. Dixon reported, Joe Dixon reported, that the State Land Department had extended the term of the St. John's gas unit through January 2017, and that the unit would remain in force as long thereafter as long as there was production, which gives a little context to granting the temporary abandonment permits.
So does that hinge on production?
And the complication here is that the production is limited now because of various limitations until a pipeline is built. In other words, they can't really produce that field until they have a market and a pipeline to deliver the gas, the CO2 to the market.
It would seem like, since the other line, the other information above, limits it to production, that we would need to take a separate action to work with the current circumstances of no production.
Can we do a quick motion just to continue this until, for the next 5 years or something? Just take care of it right now?
Yeah, once the field would actually go into production, the unit agreement would just extend indefinitely as long as it was producing.
Yep. But see, the problem, the difference here is a number of those wells are already tested and determined to be productive. The only problem is they can't get the gas to market. So I would qualify those wells as production, even though they're shut in.
Can we just do it with a quick motion and wrap it up? Just a motion to...
Yeah, I move that we extend the temporary abandonment blanket permission for the duration of the St. John's unit, which has been just extended for another 5 years.
Before we have a second on that, Rick, is there any issues with regard to...
I was just going to read agenda number 6, which is extending blanket temporary abandonment TA status. I believe that gives you the ability to have a vote on it today.
I second Dale's motion.
Could I interject here?
Sure.
My name is Mike Hannigan. I'm with Kinder Morgan CO2 Company. I came down from the Cortez, Colorado field office. If you look at the regulation 12-7-125 regarding the temporary abandonment status, there's a statement in there that the operator needs to demonstrate to a quorum of the commission future beneficial use of the well, and that's really what we're seeking here as far as evidence of casing integrity, other well records, things like that. We're going to provide those routinely because as a company we have our own O&M procedures that we need to follow regarding temporary abandonment. So I guess the benefit of the blanket TA status regards making that demonstration of future beneficial use.
At this time, are you requesting then the opportunity to come forward and provide additional information in regards to beneficial use?
I guess what I'm requesting is a little clarification regarding what the commission might require as far as demonstration of future beneficial use.
Good question.
Okay.
Well, this is Dale. I think once they provide drill stem test or some sort of testing procedure that shows that there is adequate gas flow to make it a commercially viable well, that would be considered, establish the productive capability of that well. Obviously, the casing, the testing, has to be done also before the actual abandonment of a well.
we're looking at something, just a moment, Dale.
Okay.
And to piggyback on Dale's comment, obviously whatever you filed with the state land to extend would certainly be helpful. And I think also a letter from you telling us why, we know what, telling us why you want to basically keep the temporary status and why you can't produce now and why you want to, basically, we do understand the, the various reasons that are here, but if you formally tell us why you want the temporary status and what you're hoping, in the future to be, that would be helpful as well. Because as I've always understood it, basically our mission statement here is to promote oil and gas in the state of Arizona. So I think we look at things from the standpoint that we want to help grow this industry versus basically hinder this industry. So from that standpoint, we're certainly willing to work with you as long as you can give us some information why you want what you want. And I think the fact that you send information to the state and they've agreed to it, I think without not looking at it, but I think that probably most of what you would need to supply has already been supplied to the state, plus what Dale said as far as the integrities of the wells, that we know that the wells are still out there and they're in good shape.
So maybe as a suggestion, we could table this to next meeting?
I withdraw my second, so.
Thank you.
Would it perhaps be basically an application, to consider the application to extend temporary abandonment to coincide with the state land department's granting?
I think that's a nice way of putting it. Did you want to make a motion to consider that?
We're turning in our MITs. That's what we've just recently done to show proof mechanical integrity of each of the wells. And so basically that gives us the TA status.
Is that document submitted to state land or?
It's, yeah, the oil.
Or is it oil and gas?
The three sundry notices that you sent recently, is that the ones you're talking about?
Right. Well, all of the previous.
Well, yeah,
all
but the
of
most
them.
recently was those three, right? Yeah. I have those.
The TA reports that we submit.
Yeah,
on the
he's been submitting a slew of them since last summer.
But that's the technical portion that we have no trouble fulfilling that responsibility. It's the language prior to the description of the technical requirements, that making the demonstration to the commission that there is a future beneficial use.
Right.
And that, rather than every time we do a request for TA status, rather than, I guess, making a demonstration of future beneficial use every time we either extend a TA status or request a new TA status, that, I guess that's something that we could do is submit the same letter and copy of the unit agreement to the commission to demonstrate future beneficial use, or we could continue fulfilling that requirement through this blanket TA status.
Dale, do you want to modify or withdraw your motion?
Well, I'll withdraw it and let you take care of that in the commission meeting.
Would you fill Dale in quickly on what we were reading there?
We're looking at R12-7-125. An operator may temporarily abandon or shut in a well for up to 5 years if the operator demonstrates to a quorum of the commission a future beneficial use of the well and submits a sundry notice to the commission containing the following information: evidence of casing integrity as required by R12-7-112, including a complete description of the current casing, cementing, and perforation record of the well. Next, the stimulation and cement squeeze record and complete data of the results of any well test performed to date. And next, all other well data required in R12-7-121A.
That's what they've been submitting since mid to early summer.
So really all you're looking for is almost like a one-page letter referring to the information they've already submitted through other
To state land.
means, but a one-page letter just requesting us to recognize the future potential economic benefits of the field and grant them 5-year. I mean, it's just if I understand it, what helps us is just like a one-letter application for the, a one-page letter application.
My motivation is because I've been an employee of a regulatory agency for long. It's very ingrained into me. I want documentation to defend in case somebody challenges us for being rather too laid back and too cavalier in how we deal with these regulations. And I'm not looking to fustigate the process or be a speed bump for Kinder Morgan. What my hope was is that the board would just say, yes, we agree, it should be extended for another 5 years. And if that meant then I would follow with a letter to them, then it's in the public record that the commission has made that determination, we're done. And then as they need to for other wells to submit other sundry notices, they just, this wasn't meant to be a speed bump or prolong the agony. I was hoping that this could just be something's discussed. And
Rick, what is appropriate from a legal perspective and our options for this?
From a legal perspective, I would prefer the writing because the rule calls for operator demonstrates to quorum the beneficial use. But I don't think we are looking at a 150-page engineering report. We are looking for, we submitted the following documents, we do intend production, or we are anticipating production. And this is, I understand the problem with too much paper, but I would rather have the writing in place because the rule requires it rather than have a vote without the rule, without the paper, without a single page making reference to your file with the state lands, so that if someone in the public domain decides they need to look into what you're doing, they have a trail to run down so that we are transparent to the public, which is always of concern. That was my thought.
And has this not been done in the past? Did you not submit stuff like that in the past? With the past TA, blanket TA?
Yeah, we did submit it. It is a part of the well file, but it was never referenced to in a single letter. That.
No.
Now, when we requested this motion, Steve Rossi was the administrator at that time. There was a letter of discussion on, there's been well tests provided for the wells to demonstrate that the wells do have future beneficial use. And then, of course, the whole well file record of the logs and everything was provided. So I think at that time there was no formal letter submitted to him saying, you know, referencing all the well file information that's there. But certainly we can do that.
No, I know.
I don't, again, want to create a large speed bump. However, this is a state agency, and in looking at our rules, I would rather have add a minor inconvenience to you of a letter, just because we have to be transparent as a state agency. All right.
So the resolution is that what? What do I put in the minutes here?
Well, do we need a motion?
You need a motion.
I move that we table the vote on this until Kinder Morgan has presented the material to us and bring it up at our next February 17th meeting.
And will they submit a letter in the meantime?
I was just about to go back to Kinder Morgan and suggest that a vote on this at the next meeting it hinges upon you submitting a one-page letter that satisfies the statute, so that we follow within the transparency laws of the state and we keep better record. Okay. Is that a problem, gentlemen? Sir, in the blue shirt, if you could state your name for me, please.
Thomas White.
Thank you very much.
And Rick, just so we're clear, the temporary abandonment status still remains in effect until the commission takes an action on it?
That's correct.
Okay, so there will be no lapse?
That is the next concern, yes.
Need a second?
Yes.
Second.
All in favor?
Aye.
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 Any opposed? The ayes carry. Any other discussion before we move on to the next item? Okay, number 7, report of the Oil and Gas Administrator on permits and drilling activity. Dennis?
Okay, so we had a hearing on November 15th in regards to 3 permit applications of well spacing exceptions. Those were approved on the 18th. I did some inspections and things were generally ship-shape, no issues. Just as an update, because I noticed from looking at past minutes, Steve and Niall both used to mention when there was other activity going on. So most recently, Kinder Morgan has submitted some more sundry notices about TA status. I don't think we need to belabor that again, but just gives a little detail of what they were about. There's other helium interests in Arizona. I've been approached by a number of people on the phone or face-to-face meetings. So this business of drilling for helium in Apache, Navajo, and Coconino counties is warming up. It's going to get pretty interesting, and looking forward to working with a lot of those folks as they come forward with a formal application. I would say that for those in the room that may be submitting future applications that haven't done so with the state or with the commission, as me as administrator in the past, that you give me a call and a heads up that you're about to do something. And if you're in town, that we sit down and have a face-to-face meeting, just so that both sides understand each other, what your intents are and approaches, so there's no delays, because my intention is, as soon as it lands on my desk, to get busy on it and approve it. But within ADQ, we have a fairly sophisticated electronic tracking system. It's called Azurite. It's a Oracle-based thing, and I have to be very diligent in keeping that up to date. Otherwise, it starts sending me all these little reminder emails, and so the faster I get that done, the better it is for you. But just a face-to-face meeting in advance would really be appreciated as a meet and greet, if nothing else.
Dennis, does that work for the tickler files?
That speaks to, wasn't thinking of a tickler file in that regard. The tickler file, as I understood it, is more in context of a confidentiality issue. Niall and I are going to be working on that. We've already had some discussions about it, and also other to-do list items that just need to be better documented, because I don't have a real good memory of storing this stuff in my head, remembering who did what, and there is no institutional memory on who's done what in the past. And Niall may be able to help me resurrect some of the documents of how it was done in the past, but right now I don't know. So that's why we have some of these discussions like today. So I want to develop procedures, because if I get captured by aliens tomorrow morning and there's no record, then I don't know what you guys are going to do.
Dennis, if you could discuss really quickly the merits of accepting deposits, that would be the R12-7.
Right, I skipped over that because I just wanted to mention about the helium interest before I launched into that. So I would like to ask the board's opinion. I don't know if it needs to have what kind of formal procedure, but I have received, one operator gave me a fairly large check for financial assurance bond money, as it were, pursuant to Section 103 of the rules, to cover 10 wells. And I had that meeting in early September when I was really a babe in the woods, and I thought that I was going to be expecting an application right on the heels of this bond money, but I've not seen any applications yet, and I'm just a little nervous about continuing to accept the financial assurance money in the absence of any permit applications. It would be my recommendation that an operator who's needing coverage under a bond because, you know, they've depleted all their other coverage or whatever, or they're a new operator in the state, come to me with the tiny little check for the permit application and also have the bond money in hand at the time you submit an application, rather than slapping me down with a whole bunch of cash and then, you know, there's no application to go with it, and months go by. I'm just a little nervous about doing that. It's a fast way for stuff to get lost. And, I want the commission's opinion on whether they'd agree with that from now on we will not accept bond money without an application at the time. Now, if it's an application, one application, and they're giving me bond money for 10 wells, that's okay, because the rule allows for that, but I really don't like the idea of receiving multi-thousand or tens of thousands of dollar check, and there's no application and no real clear intent of where they're going to drill, when they're going to drill.
Can I make a comment?
Sure.
Literally, like in the last week, I'm going through that on a thing I've developed in another state. And what's required dealing with the BLM is you have to, and this is the state, that state and the BLM work together on that. But what's required is you have to fill out your application with the Bureau of Land Management, work through all the back and forth, you know, until they're happy. And the moment they're happy and say this suits the purposes, you cannot drill until at that time you come up with your bonding, whether you do it as a cash bond or through the bond or set up an account with a, you know, Utah attorney. But somehow after your application is accepted and before you can proceed with drilling, you take care of the bonding, and then they give you a document that you take to a state licensed driller to drill the holes. That way all the money only passes at the time the company X has been diligent enough to submit the application and worked all the back and forth and been accepted by the state and the Bureau of Land Management. That's the point at which money changes hands. To me, that's real reasonable, because then you know that they're serious if you time it that way.
Yeah.
Dale, what's been historically that we've done?
I don't recall this ever coming up before, but I would certainly endorse what Dennis said, that you have to have the application in hand prior to handing over the bond money.
That's what all three say.
Rick, what's our legal perspective on that?
I don't think the statute says one way or another. However, from an accounting point of view, I'm somewhat hesitant to accept money without a permit with it, with a fear that somehow a subsequent permit misses that bond money somewhere. Just from a strictly accounting point of view, I'd like to keep them as close together as possible so that they track together, and when someone is done and they plug and abandon, you know, we track where the bond money goes.
Yeah.
That's my concern.
I just think it makes common sense.
It doesn't.
It's kind of a no-brainer to me.
Can I make a point? If you look at 104, doesn't it kind of imply that if you have the bond but not the application, that it's incomplete, and so then it would just be easy enough to reject it, return it?
Well, I didn't view it as an application. It could be interpreted that way. I guess, does that infer that, would you infer from that I should be returning that money then?
Yeah, because it says the complete application package shall contain, and then they specify 6 items, one of those being number 5, a performance bond is required. If you have the bond but not the other items, it's not complete and you can just reject it.
So in other words,
Return it, sorry.
Return the money. Well, that was a lurking question. Go ahead, Gordon.
When I submitted the $25,000 to you, it was along with the sundry notice, and that was to be applied for Arizona Energy Partners on the 17-1.
I think there was already a bond on that.
There was a bond in place, but there was a request to release that bond and accept the $25,000 in its place.
Oh.
If you go back to the sundry notice.
Yeah, okay, I will do that. That wasn't clear to me at the time, but.
Now, we will be submitting 3 applications to the state and 3 additional ones to you for private lands. So
Okay.
there are 6 applications coming forward. But historically, Steve didn't want to look at anything else until the bond was in place.
Well, I'd kind of be the same way, but I want to see all of it together. So we should talk after the meeting. It wasn't at all clear what your intent was,
Okay.
but you know, that was like the 2nd or 3rd week of my employment here, so.
But the sundry notice did spell that out, and that was for the agency 17-1.
Okay. Well, let's have a further discussion offline.
Moving forward, do we need to have a motion or just direct Dennis to do it in this form?
Just direct me.
At this point, suggestion would be, one of the agenda items that's coming up is rule rewrites in the 5-year review, is to suggest that it be considered during that period of time, but I don't think the board has to take a position right now or a vote right now.
Dennis, let's move on then, unless there's other discussion, on to new certification documents, concepts for permits and so forth.
Right. So, bear with me here. In the past, this is the so-called permit that has been issued. I should probably reduce it so you can see. You don't need to read the fine print, but this is a carbonless copy with 3 sheets that's been used for decades. I want to move to something much more formal, and this permit itself, in my view, is not a permit. I would prefer instead to create a document that certifies they've submitted a permit and have the authorization to drill that might look more like this. And just for your entertainment, I'd pass around to the commission at least, just as a little mock-up. It's all fictitious. It's just to give you an example. The rule requires that the operator post the previous document or this document at the drilling site, and I would submit that this thing be revised to be a certificate that authorizes them to drill. The thing you have in your hand that is being passed around is a little bit stout enough so that you can stick it inside of a plastic sleeve, and you can endure the weather a little better than just a flimsy sheet of paper. And that would be your official document, and it would have the necessary information, the sites that you submitted an application, that you are authorized to drill in accordance with the rule citations that are there. It'd have my signature, the date, the API number. The receipt number is the receipt for the permit fee, that astronomical $25. And, just make it official that you have going forward something from us that says you can do it. In accordance with what Frank was talking about, in terms of his experience that he's been visiting operators that are not clear what their responsibilities are in the field, I want to develop a permit that might have the contents as you see on the screen right now. There'd be a part 1, all that part 1, 2, 3, and so forth, all says standard, meaning to be standard language that be developed from the rule, and I cited the rule there. I don't know if you want me to enlarge it some more, I can. It's a little hard to read, but anyway, I haven't developed this document yet. This is something I'll be doing this year. But what I would like to do, is have this replace the carbonless copy immediately as of today. I've got no applications to drill yet this year, but I'd like to start this year with this kind of a document. But over time...
What's that current one look like?
Oh, well, let me show you.
Can you flip back to that?
Yeah, hold on a second. It's this thing. It's a carbonless copy.
Okay, so that replaces this.
So this is the carbonless copy, 3 sheets. It's pink and yellow and white, and I think the white gets mailed to the operator.
So basically you're just proposing a change in the
A change that's more upgraded, yeah. I mean that's not been changed. It still has the date at 19 blank.
The information's all
2017.
still there and
Yeah.
need.
The other thing I would say, it's just the way it's going to be, I'm afraid, but the permit number there down in the lower left corner, those were sequentially printed, pre-printed with these carbonless copies, the permit number from now on is going to be something that's generated by this Azurite database I was telling you about, this tracking system that ADQ has. And it talks about their, on the top there, permit/LTF number. LTF is licensing timeframes. That's a statewide statute that is for issuing licenses. The commission is in fact issuing a license to an operator to perform a function, in this case drill a well. Our Azurite database in ADQ, a lot of people use this LTF number. It's a unique number to create the permit number. So that's the number that's going to be, instead of 1214 or whatever. It's a minor procedural thing, but it's the way we track it in the Azurite database.
Does this require action by us, or just
Well, no, this
accept
is
as
pretty much
notification
FYI.
that the form has been changed?
It's just for us to discuss and see if we like it or make recommendations.
Yeah, make some critiques to it.
Or stay with what we've got.
I like it.
Personally, I appreciate, Dennis, you bringing this to our attention, but I think these are really administrative matters, and they're not really commission matters there.
Okay.
But I realize that we've got to come to the we've got to go to the modern age, kicking and screaming, and we appreciate the fact that you're trying to do that.
So neither this nor this document, the commission has any interest in providing input or approving or anything?
This is Dale. I have a question, Dennis.
Yes.
Now, will these permit numbers be continuous from the ones that we already have established?
No, I won't be going with that. The next permit number in the carbonless copy thing, I think, is 01215. That's not what it's going to be. In fact, it'll be this licensing timeframe number, which is, I think, a 5-digit number or a 6-digit number. They will go up in number, but they won't be necessarily sequentially numbered. So, for example, if I get an application to drill today and I get it into the Azurite database system, it's going to generate an LTF number that might be 67778. And then 2 weeks from now, I get the same operator wants to send me another one, and I go back to Azurite, and it may give me a number that's 72215. I mean, it's higher than the 67778, but they're not going to be side by side because everybody else in the agency is using Azurite and they're generating their own LTF numbers. But there won't be any redundancy. You'll not be seeing two permits with the same LTF number, and that's how they'll be filed in the well files also. It'll just be a bigger number.
Okay. What is the latest number that, our permit number that we have?
01215 would be the next one. I think Ranger took the last 3 last year. I would suggest that Ranger might ought to save those for historic purposes. Maybe money someday.
Okay.
Any other discussion on this?
Yeah, Dennis, to get to the part that you got on the screen, the packet that you're preparing, certainly that's administrative as well, but maybe you might want to consider going to some type of a YouTube video or something, just giving them what instructions they need to fill out, what the forms are. It might be a lot easier task for you because you can reference those regulations that they've got to look at, and just remember the camera will make you look 10 pounds heavier.
I like that suggestion. That's a good idea.
Okay, just
have a television star here.
Please don't make a motion for that. In all seriousness, though, the top of that thing there says cover sheet / instructions. So it would explain to an operator procedures. You know, step 1, fill out this form. Step 2, attach a check, etc. Expect the administrator performing an inspection during the life of the well. But it's going to go from soup to nuts. It's going to mean that when it's time for you to do completion, you have to do it in accordance with the rule in that area. It's sometime down the road, or if it's a dry hole right away, what you got to do to plug and abandon it. The one section there, part 4, optional / reserve, would be reserved for those wells that are disposal wells, storage wells for underground injection, natural gas storage, a geothermal well, you know. So-
Are you gonna go to PDF fillable on those?
I sure hope so, yeah. I've got to learn how to do that. I want to do a PDF fillable on a lot of documents that are on the website right now.
It's called an intern.
Dennis and I have spoken.
I'll show up.
About this, and with being able to do the applications online, issue the certification and so forth, to streamline the operation a bit.
It's good, yeah.
Okay, well, I might as well go on the record. I may get slapped for this by either some in the room or outside the room if it gets out of this room, but the agency has no budget for supporting this program. We're finding money to pay my salary, but it was made clear to me when I interviewed that I would have no administrative support. So I kicked and screened everything else and was able to bring Niall on board for a temporary period of time. But I fully support, Mr. Cooper, what you're saying about an intern, but am I going to get one? Good luck.
They're intern or extern, sometimes you don't get college credit if you get paid.
So you get it for free.
Well, again, if I could work with our HPO to develop that concept, I'd love to do that. I've run into a brick wall with that because I had originally thought it'd be nice to have Niall as a volunteer indefinitely. Sort of like a call, but
He needs all the college credit he can get.
so yeah, it sure does. But seriously, no, if I could do something with a college intern, if our human potential office would be receptive to that, yeah, it's a good suggestion. I'm not against it, believe me, I'm not against it. I've tried, but just been a brick wall. Sort of the immovable object is meeting the irresistible force.
Frank, do
Meeting
you
the
have,
force.
can you give some thought to that and see with your various contacts and whatnot if there might be a solution?
I was going to contact ASU, and I was thinking that maybe we could just put ASU directly together with you and whoever else here and see if we can.
Yeah.
I can know from the Attorney General's point of, we do the same thing. We have interns that don't get paid, but they come in because they need the background for to graduate from the university in their law program. And certainly, if there's more questions from your HR people, maybe your people should talk to my people. Because taking advantage of, very inspirational young labor force who really want to prove themselves.
Yeah, I know.
Very beneficial.
I agree.
Even the governor's office uses them.
Yeah.
And plus, they can do things on a computer that we can't.
Yeah, I know. Well, I started beating the drums to get Niall on board in September, if that gives you an idea of the...
Is there no kind of grant program or anything through a petroleum industry? I'm just a question, I don't know, but I'm just wondering if there's any sort of a grant or something that you can apply for to, pay for a Niall or somebody that you actually have to pay to do stuff?
I don't know the answer to that. I'm not averse to looking into it, but it does take away time from writing grant proposals is
yeah, I understand
big
that.
deal.
It's just a thought, because I know that.
If I really thought I was going to need something long-term, it might be worth the effort, but I'm thinking that in the past, lone individuals, lone wolves were managing this program adequately, so I'm sure I can do the same, but it's just short-term help to do some of these background things like fillable PDFs and stuff.
Yeah,
I'd like to get
this
them
is
on
Dale.
board faster than sooner than later.
Dale, go ahead.
Yeah, I'm a little cautious about asking them write grants to do what the state of Arizona should be paying for. Now, and I like the idea of interns. I've had many interns when I was a professor at NAU. They worked for the Forest Service, for the Park Service, for some other, generally agencies like the BLM, and they actually were paid, and they still got college credit. So it all depends upon the program at the university, whether they could get credit for that or not. But I certainly discourage asking Dennis to step out and try to raise money to get an assistant for himself. It's better to not get the work done than to ask him to do more. That's my opinion.
Thank you.
Fair enough.
My thought is we make inquiry into at the university level, or Frank, if you can.
I'll make a few calls.
Yeah. Dennis, and also if there's some other state that has a format that you really like, they're doing, let's ask them how they did it. Because, we don't need,
Oh, yeah,
yeah, we
sure.
don't need to reinvent the wheel.
Yeah, I agree. There's a number of things on my mind, and I think me working with the AZOGCC, they might be able to provide some guidance on that also. We're coming to that point where I'm going to start having to have those kind of conversations. Up to now, just been too much else to do, so.
Any other discussions before we move on to 8?
Just a quick question, will the permits still be posted on the website?
Yeah, yeah, that's another thing that Niall and I need to get caught up on and get that website. Yeah.
And that's coming up in the next item anyways, on the website. So anything else before we move on to 8?
Can I just, one quick question, is there any guideline for posting on location? Is that spelled out, or should it say conspicuous?
Yeah, it does on the new form. Yeah, I think it might have said something in the fine print on the Cardinal's copy. Let's see here. I don't know if you can see it down there at the bottom. Operator shall display the certificate of conspicuous place on site. It's your choice. I mean, if you want to attach it to the derrick of the drill, or
Sure.
if there's a trailer there.
So while the drilling of the well is active, and then as soon as the rig's released, then you don't have to do that anymore?
That would be my intent, yeah. Once the well needs to be adequately marked, and that's what the permit would talk about, is that there's some requirements in there for signage and so on and so forth that has to stay with the well once it's producing. Or if it's plugged and abandoned, it has to follow a strict procedure. But yeah, that's basically for when the thing's being drilled.
Sure. Thank you.
It says permit to, or should say permit to drill in there. So, yeah.
Dennis, if you're going to go to the non-sequential numbering for the permits in the future, do you have a separate mechanism to track the total number of permits that are going to be?
Yeah, that's through this Azurite system. Azurite is a acronym for Arizona Unified Repository Information Technology something. I don't know what it is, but anyway, it's a clever acronym for Azurite, which is a mineral for copper, which is what Arizona is known for. So yeah, it's a very complex Oracle database. It does a lot. It's not user-friendly either, but it does a lot.
I'm glad they didn't iron pyrite.
Yeah. Yeah, no.
Okay, then, barring any other discussion, we'll move on to item 8. Dennis, one other thing that in item 8 to address is the AZOGCC. So if you could talk about each one of these points.
Okay, well, let me get the good news out of the way first. As far as drill cutting samples, I have not ever formally announced, I think most of you already know, but I'm not going to have to move all the drill cutting samples out of the basement of the former Arizona Geological Survey to a new location. Our facilities manager was able to work out a formal contract with the Arizona Department of Administration, who actually owns that building where the AZGS used to be housed, that we just rent the space in the basement where the cuttings and the core and so on and so forth are. And it'll stay there hopefully indefinitely. And that was a ferocious nightmare that I was not looking forward to, and that's why I wanted to have a meeting down there, which I still hope we can sometime when the pressures of these other issues aren't so great. I wanted to show you, some of you have never seen it, and just showed you, it's not much of a collection in the context of what other states have, but it's still a fairly unique thing, and to try to move it because some parts of it are so old, I have no faith that it can be moved properly without it being damaged or lost. So the good news is we don't have to worry about it.
Dennis, I have something on that.
Yeah, go ahead.
Congratulations on that.
Well, I don't get the congratulations. Our facilities manager did all the legwork, and I'm eternally grateful to him for that.
But I have a caution. That may change in the future. I can't predict that, but it could change in the future, and you'd be back to square one.
Oh yeah, you're right. Yeah, nothing's permanent, but I don't want to think about it anymore. That's why I just laid it out there. Is we're done. Let's move on.
But no, I have another suggestion. The Arizona Geological Survey, of course, has inherited that museum in the capital area, that what used to be the Minerals Museum. I talked to Mike Wagner, Mike, what's his name?
Conway.
Yeah, anyway, I think that we should look into the possibility of space in that museum for this collection in case it ever has to be moved.
Just kind of reserved.
Yeah, you mean if in the eventuality that I get an eviction notice from DOA?
Yeah, I think we should consider the possibility of that collection going into that museum in Phoenix, which used to be the Mines and Mineral Resources Museum. It would just be a matter of looking into the possibilities, is all I'm suggesting.
Dale, this is Niall.
Yes.
That's a great idea, but it's maybe a little premature. At present, other than dead storage, they're not allowed to access or occupy that facility. And the University of Arizona, who really has the money to remodel and reopen it, is not moving very fast at this time.
And that, I understand that.
So it's a good thing to watch and wait, see what develops.
Yeah.
Okay, and then the next good news is that finally, all of the well files have been moved from Tucson to the first floor of this building, and I have ready access to all the well files going back to even the earliest days when the State Land Department was having wells drilled that predates the commission. That wasn't quite a Herculean effort that moving the drill cuttings would have been, but it proved to be a bigger issue than I anticipated, and that's why it took so long, including when the boxes arrived up here and Niall and I were unpacking them, we discovered that some boxes had been shuffled like cards, not because the lady who manages the Record Management Center didn't put them in the boxes right. She put them in the boxes exactly as they were on the shelves down in Tucson. They were mixed up, so I had told Niall, he helped me on Tuesday, that that's probably half a day of it, but he was all day. We were here till almost 6 o'clock, making sure it was up and copacetic. So it's there, and it's accessible, and that's another big load off my mind. Miscellaneous files, some of those are still in Tucson, and some may come up here. There's still room in the shelves for some more files. Some of it will stay in Tucson. You had questions, Frank, about the Oil and Gas Conservation, Arizona Oil and Gas Conservation Commission website. Was that your?
Yes, what the status is on the website and then the AZOGCC.
Okay, in terms of the status of this website, it's my understanding it's going to remain under the control of ADEQ. I think there's a different kind of HTML language that was used to create this website versus how DEQ does it. Sometime this year, I think there may be some conversion to the new language. I don't know what it will do in terms of changing the appearance, but all these tabs are at the top here. I can only say over my dead body, are those things going to go away? The GIS maps, the publications, the permits, production reports. I'm behind the 8 ball in getting production reports up to date, but I hope to work on that. I mean, there may be some changes to this because hopefully it will be improved. For example, one thing that we've changed here is a request for public records. I was getting all the requests for everything that ADEQ has a records management center, and a lot of the kinds of requests I was getting can be handled by the records management center. So we refashioned this page to say if you have a public records request, fill out the form that you see online here and submit it, and it'll go to the records management center. If it's technical assistance you're looking for, then you should contact the person, OGCC at azdeq.gov, with an email. Niall suggested that in addition to the rule Arizona Administrative Code, which is here, if I click that link, it takes you to the oil and gas well, I guess rules, but also to have a PDF available of the statute in this area and here. That's yet to be done, but that's a to-do list. I don't know, does that satisfy, or did you want to go over some more details in regards to, like Niall, I've been talking about refurbishing dead links and removing some stuff and all that? Was that what you were looking for?
Yes, and ensuring that we keep the information for potential drillers up there and get everybody's input on how they think this should be put together. And by the way, I apologize for all this extra time, but with the switch over and the deaths and so many people being laid off, it's causing some extra work to bring everybody up to speed. So thank you for all the extra time and that you're having put forth for this.
Dennis, on the public records, you may want to talk to Rick or someone in Rick's office about that, because some agencies that I represent, we're getting public records requests basically from people wanting to know salaries and all these other things, a lot of things that are really not truly, within the, that it's for a commercial purpose, but they're trying to avoid having to pay, for the cost and time of reproducing them. And I think that there's forms that can be supplied to you through the Attorney General's office that would have basically the things that they need to fill in to do a valid and proper public records request.
Well, we have a procedure within DEQ that speaks to those kinds of things. There's forms to fill out if necessary. I'm not sure, the link may be on here, but anyway, there is a link that you can go to ADQ's website for a public records request, and it looks a little different than this, but this just tried to speak to me getting an email or the agency getting an email requesting copies of well file XYZ, and so you get it, emailed or whatever, or production reports, and just get that kind of thing.
But, in that type of scenario, though, that may be a commercial request.
Well, then we have a charge that we assess for commercial type stuff.
But that will trigger ADEQ's request for records then?
Yeah.
Okay. Yeah, Dennis and I have had discussions, by the way, with respect to the separation of the commission from ADEQ, and so that we're moving in a separate way, because certainly their regulations and ours are different, and they're statutory versus our administrative support. So we've tried to make sure that as we move forward, there's this clear division.
Does that include the header on the agenda that we're...
Well, that's one of the things I was also going to bring up, about the Oil and Gas Commission at the head of the agenda, but versus the DEQ. So, anyway, what about the IOGCC?
The question pertains specifically to what?
Our membership, what's our relationship with the IOGCC?
It's still intact. The agency, ADQ, doesn't have the budget to pay for renewed dues. Had a conversation with Dale yesterday about this, just to make sure I was not talking through my hat or something, but it's my understanding that those dues are voluntary. There's either an active membership of $7,500 a year or an associate membership of $1,500 a year. In the past, we've been paying for an active membership. In the immediate past, the Arizona Geological Survey was able to pay those dues because they had enough money coming in from grants or private contributions or however else Dr. Allison generated revenue for the agency to be able to afford to pay for those dues annually. Both Dale and I think, have had verbal conversations with our senior representatives in the IOGC about the dues, and gotten feedback from Dale and from people in the IOGCC that they are voluntary, and we understand if you're not able to pay now, you're still an active member.
That's correct. That's the way it is.
One idea I'd had, and this is just informal, I'm not even sure I'd put this in the minutes, but one idea I thought I'd had is that sometime in the future, we're hoping to change the permit fee to something a little bit higher and more sustainable for this program, maybe permit fees can go towards paying membership. They're never going to be able to, there's never going to be enough revenue from a permitting program to support the administrative costs the agency has for running this program. That's a no-brainer. We talked about that in early meetings, but maybe permit fees can go to paying for annual membership in the AZOGCC if that's allowed. But I'm just a thinking out loud type of thing, but I have thought about it.
How would we pursue an appropriation in the budget for the next fiscal year?
I think you'd need to talk to ADQ, Executive Leadership Team, or the, was it the Joint Legislative Budget Committee? I don't even know if that's, I really don't know the answer to that, but you could start with a dialogue with people in the know in the agency. If you need a specific name, I can get you one right now. I don't know who that is.
What's been the, Dale, what's been the budget in the past? Do you have any idea?
Well, the IOGCC determines the amount of the membership, the dues, based upon production. And therefore, say the state of Texas pays a lot more than the state of Arizona, just because of the increased, much more production there. It's been fixed at $3,000 the last I remember, and that's what Lee Allison was able to come up with for the annual dues for the IOGCC.
$3,000?
However, keep in mind, we are members. We're full-fledged members, whether we pay the dues or not.
Well, I have an invoice that says $7,500, and I think a confirming email sometime later that said that. But you say Lee only paid $3,000?
Yeah, Lee paid $3,000. That's my memory. We will get billed like the $7,500 that you just said, and that's based upon the IOGC's calculations based upon state production in given states. But Lee, I think, just paid $3,000 sort of as a courtesy, because that's all he could come up with.
Actually, where I was coming from, Dale, on that was the budget, overall budget that Lee had for the commission over the years, with an eye on what ADEQ should have for us, and if they're going to ask the legislature for funds, what they should be asking for.
Well, I think we should ask for the fees for the IOGCC membership, whatever they happen to be. Now, and whether we'll get them or not, I think we should ask for them. I think that's a legitimate expense for the state of Arizona to support that.
Can't get what you don't ask for. You can't get what you don't ask for.
That's true.
That's right.
I think that we should, and if I was the legislature and Dale and Frank got me in a room, I'm pretty sure I'd have to concede at some, probably very quickly into the conversation that was the right thing to do.
Okay. Any other discussion on this before we move forward? Okay. Next one is call to the public. Does anybody have anything they'd like to say to the commission? Nothing. Any announcements? Moving on to 10. The 5-year rule, we need to address that in I should say 5-year review. We need to take a look at that and address that. And I'd like to see us start talking about that at the next meeting in February. Is there any comments on that, or?
You probably need to put that on the agenda.
Yeah,
have a discussion.
it will be on the agenda next time.
I have a question. Is that hearing that I have on my calendar for the 26th, is that the one that's been canceled?
That's been canceled.
Okay.
Dale, any thoughts on the 5-year rule review?
Yeah, I have contacted the AZOGCC people and asked them to provide a review of our rules, to help Dennis to go through that to meet that requirement. And he told me just yesterday that they did not respond to him. So I'm going to follow up with that again. I'll call Mike Smith, the executive director, and ask that they get in touch again, which they haven't done yet, with Dennis, and just find out what they have to offer to help us. But they have a committee that actually does that. So I'll follow up on that starting probably next Monday.
Okay, fantastic. Thank you, Dale. Then I look at any other discussions before we move on to adjournment.
Quick question.
Yes.
You asked for comments from the industry by the 27th of January, right? Yes.
Yeah, that was originally, yeah.
Okay.
Hearing nothing else, do I have a motion to adjourn?
So moved.
Second?
Second.
All in favor?
Aye.
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 Any opposed? Motion carries. We're adjourned.
Okay, I have an informal discussion I have to have.
Dale, thank you.
Stuff.
Basic.